of our webinar today. And this one will be addressing the issue of consumer protection enforcement and redress, national and international perspectives. And we kick off this session with a presentation from Romel Hippolyte, economist at the CARICOM Competition Commission. He will be speaking on the issue of assessing consumer detriment, a tool for consumer protection. Romel, you have the floor.
Yes, Barry, I'm just loading my slides now. Just give me a...
So in the meantime, while Romel is getting ready, I will be putting a link to a feedback survey in the chat. So those of you, please take a look at that either during or before the end of the webinar, depending on how long you can stay, and give us your feedback on what you've heard or seen so far today.
Yep. So can everyone see the presentation?
Yes, we can see it, Romel.
Okay. So good morning, good afternoon, and good evening, everyone, depending on wherever in the world you're joining us from. As indicated by Barry, my name is Romel Hippolyte, and my job today is to set the stage for our presenters in this section of the program who will be discussing consumer protection enforcement. So in other words, I'll be presenting the appetizer before diving into the meat of the issue, which is enforcement issues. So I think that it is necessary that, before we speak about those hardcore issues, that we talk a little bit about consumer detriment. So in terms of the layout of my presentation, we're first going to define consumer detriment. Then we're going to talk about why consumer detriment is important. We're going to briefly, if we have time, talk about how to conduct a consumer detriment study. And then I'll give a couple examples of recent detriment studies that have been conducted. So what is consumer detriment? And you can see here from the definition, consumer detriment refers to the harm or disadvantage experienced by customers as a result of unfair or deceptive practices, inadequate product quality, poor service, or other negative aspects of the marketplace. So it can arise when consumers are treated unfairly, misled, or suffer financial losses due to the actions of businesses or service providers. So consumer detriment can take various forms, including financial losses. So consumers may experience monetary harm through deceptive pricing, unfair contract terms, or fraudulent activities. Unsafe products, consumers may face physical harm or health risks due to defective or unsafe products. Poor quality or performance, consumers may suffer from products or services that fail to meet their expected standards, including durability, reliability, or performance. Misleading or deceptive practices, and you can see the picture here of what is advertised and what really you get when you might go into a particular restaurant. So consumers might be misled by false advertising, deceptive marketing, or inaccurate product claims, leading to uninformed purchasing decisions. You can also experience detriment through unfair treatment, where consumers may encounter unfair practices, such as discriminatory behavior, hidden charges, or abusive customer service. And you can experience detriment through lack of information or transparency, where consumers may be disadvantaged by a lack of clear and transparent information, making it difficult to compare products, understand terms and conditions, or make well-informed choices. So now that we know what consumer detriment is, it is relevant. A relevant question to ask is, why is understanding consumer detriment important? So understanding consumer detriment is crucial for consumer policy development and consumer protection enforcement for several reasons. First, effective policy development. A thorough understanding of consumer detriment allows policymakers to identify areas of concern and prioritize policy initiatives accordingly. By understanding the specific types and extent of harm consumers face, policymakers can design targeted measures to address these issues and protect consumer interests. Evidence-based decision making. Consumer detriment studies provide empirical evidence and data that can inform policy decisions. They help policymakers assess the impact of existing regulation, identify gaps in consumer protection frameworks, and develop evidence-based solutions to address consumer harm effectively. Proactive risk mitigation. By understanding consumer detriment, policymakers and regulatory authorities can proactively identify and address potential risks before they escalate. This includes anticipating emerging issues, monitoring industry practices, and implementing preventative measures to protect consumers from harm. Strengthening consumer rights. Understanding consumer detriment helps identify areas where consumer rights are being violated or compromised. This knowledge informs the development of legislation, regulations, and enforcement mechanisms that enhance consumer rights, improve market fairness, and promote consumer trust and confidence. Consumer detriment can also help with targeted enforcement and compliance. Consumer detriment studies can assist enforcement agencies in targeting their resources effectively by identifying sectors, industries, or specific practices associated with significant consumer harm. The evaluation of effectiveness. Consumer detriment studies provide a baseline for evaluating the effectiveness of consumer protection measures. So by periodically assessing the impact of policies and regulations, policymakers can make necessary adjustments, strengthen enforcement mechanisms, and ensure that consumer protection measures remain relevant and effective over time. So how do we assess detriment? Well, consumer detriment studies aim to A, quantify and understand the extent of harm experienced by consumers in various sectors, industries, or countries. And B, identify ways where consumer protection measures and regulatory interventions may be needed to address the identified issues and protect consumers from harm. So in terms of a methodology, these are the particular methodological steps that are taken in conducting a consumer detriment study. So you might start clearly defining the research objectives, which might include identifying the types and extent of consumer harm, understanding the underlying causes, assessing the financial impact on consumers, or evaluating the effectiveness of consumer protection measures. You might want to design a study framework where researchers need to develop a framework that outlines the scope of the study, which industries you're going to target, how you're going to collect data, which analytical approach that you're going to take. The next step might be data collection. So you might want to look at if you're going to collect data from primary or secondary sources. In most cases, a lot of countries or a lot of studies would have used surveys where they would ask consumers about the particular example of a loss or losses that they would have experienced within a given year. As well as some studies would look at how consumers seek to overcome that particular detriment, what kind of solutions that they would have sought. So for instance, some studies might contain aspects where they might ask about if they are well informed about the Consumer Protection Agency, if they've used that as a particular avenue to try to overcome the detriment or get back any money or any financial loss that they would have taken. With all the information that you've collected, then there's the issue of estimating detriment. So with the data analysis, you would then try to estimate the value or magnitude of consumer detriment that has taken place. And of course, when all of that is finished, you would probably look to identify any key findings and recommendations and trends and patterns relating to stakeholders on how they address the identified issues, how much money they would have lost, how you can then improve the consumer protection framework and mitigate harm. So these are a couple of examples that I've pulled out on consumer detriment studies, examples of consumer detriment studies. So you would see here, like for instance, in 2015 in the UK, this was done by the CMA, the Markets Authority in the UK. They would have done a detriment study on a wide range of sectors, including energy, banking, retail, and communications, and they estimated the detriment to be around 4.1 billion pounds. And some of the specific important issues that they would have identified would be like poor customer service, lack of transparency, and unfair pricing practices. There was also one done in 2016 in Australia that was a little bit more focused on the financial system, and they estimated that detriment was around 1.6 billion Australian dollars. And some of the issues that they would have uncovered would have been high fees, inappropriate advice, and complex products. In 2007, the EU looked specifically again at personal current accounts, and they estimated detriment around 770 billion euros, and they identified complex pricing structures, lack of transparency, and difficulty switching between banks as pretty important issues that consumers would have faced. In the United States, there was another detriment study that specifically looked at the mobile industry, and they would have estimated detriment at $766 million, and they found misleading advertising, unfair contract terms, and inadequate customer service as major issues that were faced by consumers. And lastly, in 2019, you can see here that in Canada, they also did one that was really focused on looking at estimating the value caused by fraud and deceptive market practices. So they looked at telecoms, retail and financial services, and online scams, and they indicated that, and they estimated, sorry, that detriment was around 766 million Canadian dollars. So these are examples of studies that have been done on detriment. As you can see, that by estimating or coming up with an estimate of estimated value of detriment, it also kind of provides a platform for where you can advocate for the need for consumer protection framework or robust consumer protection framework in your jurisdiction. So at this time, I would encourage everyone to check out the Commission's website and social media platforms for some of the work we have done over the past couple of years regarding consumer protection, including our report on food prices during the pandemic and our study on air passenger rights, which focus on consumer protection framework in the region for involuntary cancellations of flights by airlines. So I wish to thank you at this point. And Barry, I will now turn the mic over to you so that you can introduce our first speaker in relation to this particular segment. Thank you.
Thanks, Romel. So now we're going to have a slight change in our expected order because one of our colleagues from the UK has another commitment. So is it possible for Mr. Jason Freeman for the Competition and Markets Authority of the UK to do his presentation on consumer redress, consumer enforcement and redress in the UK?
Hi, hello.
Jason?
Hopefully you can hear me. Yeah, can you hear me all right?
Yes, we're hearing and seeing you fine.
Excellent.
Great. Thank you very
Excellent.
much.
Well, it's great to be with you all, and thank you very much for your invitation to speak at this conference, which has been very interesting so far. Yes, it's the evening now, and I had a pre-existing arrangement, so unfortunately I have to finish by a particular time. Anyway, I will share some slides. Hopefully, I will hopefully you can see some slides which are going to appear in a minute on here we go. Can you see them? Yes. Consumer enforcement and redress in the UK. So I'm a
Yes, it's
legal
up now.
director.
We can see.
Excellent, thank you. Yes, so I'm a legal director in the Competition and Markets Authority, I've been doing this sort of enforcement work for some years now, and I wanted to tell you about our regime that exists in the UK, and hopefully you'll find that helpful. So I'm not going to talk a great deal about specific CMA investigations, um, but I will mainly focus on the legislative framework. But if people have questions about our cases, then I'm sure I'd be very happy to answer them. So let's have a look at the legal framework. So the legal framework which we use consists of a number of components. So the one which is important is the overarching enforcement framework, and that's set out in the Enterprise Act, Part 8 of the Enterprise Act, which provides the main vehicle for civil. What this effectively allows us to do is to seek an order which is very similar to an injunction to stop businesses from engaging in practices which we think infringe the law, and also to secure redress for consumers who are affected by that misconduct. Now, there are, in addition to that overarching piece of legislation, which allows us to enforce really a huge number of pieces of law, there are a number of other specific pieces of legislation which give either a means towards redress or enforcement by enforcers, or they give people private rights which individuals can enforce privately. So probably the most significant in terms of cross-cutting law is the Consumer Protection from Unfair Trading Regulations, and that sets out a number of criminal offences, and it gives private rights of redress for some of those, where consumers enter into transactions or pay money because they've been misled, actively misled, or they've been a victim of an aggressive practice. So that piece of law we can also enforce under the Enterprise Act, and we can, if we wish to, bring criminal prosecutions. The CMA, I have to say, almost never brings criminal prosecutions, and I'll come on to the reasons why shortly. There are also some other important pieces of law. The Consumer Rights Act, which provides contractual rights for goods, services, and digital content. So in consumer contracts, it replaces the Sale of Goods Act and the Supply of Goods and Services Act. So some people who have been practitioners for a while in Commonwealth jurisdictions may be familiar with the Sale of Goods Act or the Supply of Goods and Services Act, but those no longer apply in the consumer context. And Part 2 of that Act governs unfair terms, and similarly, that replaces in the consumer context the Unfair Contract Terms Act that people may be familiar with. And then there's the Consumer Contracts Information Cancellation and Additional Charges Regulations. That gives people cooling off rights, a right to information, control over surprising charges, and so on. And importantly, that gives people the right to get their money back if certain circumstances arise. So, for example, if they're not given the right information, or they just decide they want to end the contract within a 14-day cooling off period, they can have their money back. There are also numerous other rules on things like product safety, package travel, timeshare, consumer credit, which there just isn't time to go into in this short presentation, but they also provide people with certain rights to redress, which are important and can also be enforced not only individually, often there's criminal offences attached to some of these provisions, but also under the Enterprise Act. And the power of the Enterprise Act really is that it enables enforcement for a multiplicity of breaches. So we don't have to just show that something is a criminal infringement under the consumer protection regulations, for example. we could say, well, we think it's an infringement of that piece of law, and it's a breach of the Consumer Credit Act, and it's an unfair term, and we put it all into one piece of litigation, and off we go. So that's the overarching legal framework. I should say that our law, all of this law, is largely derived from EU consumer law. And as people, of course, know, the UK was a member of the European Union until recently, and therefore most of our consumer policy thinking has been conducted in the context of the EU. And so the substantive consumer protections which exist in the UK are generally the same across the European Union. Now, as of course, we've left the EU and legislation is developing separately, there will be some divergence, but so far the law remains, broadly speaking, comparable and very, very similar, if not exactly the same. The importance of this, though, is that when we're construing our law in the UK, we will still, and I suspect for some years, be having regard at least to European legal principles, the approach of the European Court of Justice, and how the law was intended to, what was the policy intention of the law when it was drafted originally in that European context. So, for example, principles like the high level of consumer protection and so on. Well, who enforces in the UK context? Well, there's a number of enforcement authorities, many enforcement authorities. And so I give a brief sort of scheme of who does the enforcement. So, of course, starting off with my organisation, the Competition and Markets Authority, we aim to carry out cross-sector enforcement of issues which are important to the UK economy kind of overall. We're not particularly focused on any particular sector, and we leave local enforcement to local trading standards. And the reason for that is because in most of the kind of specific sectors of the economy, there are sector-specific regulators who have comparable powers. So either they have administrative fining powers, or they'll have licensing powers, or they can bring enforcement action under the Enterprise Act, which I've described. So those would include the Financial Conduct Authority, which regulates in the financial services sector. There's Ofcom in the telecom sector. There's the Civil Aviation Authority, and I've written etc. because there are many others as well. And each of them have their own rule book, their own set of powers, and those powers can be quite different. And so the way the CMA tends to operate is that we will have memoranda of understanding with different organizations, and we would tend to defer to them first of all, so that they have a go at sorting out the problem. But we are not prevented from taking action if we feel we need to. And for example, one of the sectoral regulators is not doing something, and we feel that perhaps it would be better if enforcement takes place. Well, we have the power to do that. And then, of course, there's local trading standards. So local trading standards are the main enforcer of consumer law in the UK. They have by far the largest chunk of the budget, as it were, for consumer enforcement. And they will ensure general compliance across the economy. So routine enforcement, for example, of a trading standards infringement. So, a business that hasn't got its unit pricing right, or a business which is delivering short measure local trading standards, subject to their resources and the other constraints on them. They will carry out inspections. They tend to prosecute infringements, but they also carry out important work as so-called primary authorities. And that's a system whereby they give something called assured advice to businesses, which the business actually pays for. But the Trading Standards Authority will give them assured advice, and that means that if the trader complies with that advice, they know that they're not going to face enforcement action from that authority, and they'll have a primary authority relationship with a particular trading standards department. So anyway, this is all slightly complicated, but the main thing to get across is that trading standards do most of the enforcement, and depending on which jurisdiction you're from, it may be that many of the authorities perhaps who are on this call may have an enforcement practice which is more similar to trading standards than it is to the Competition and Markets Authority, because that's about compliance. And I'll explain in a moment more about how the CMA approaches its work. And then there are some statutory redress schemes. So these are schemes which are set out in legislation. Businesses which are in the particular sectors are subject to those redress schemes. They don't get a choice. So two examples of financial ombudsman. So if you're a regulated financial services provider, then you are subject to the jurisdiction of the financial ombudsman. And if you don't treat your customers as they might expect to be treated, they can bring a complaint to the financial ombudsman. The financial ombudsman can adjudicate against you, and you have to satisfy whatever the adjudicator says. And it's a similar system in the estate agent system. For example, estate agents have to be members of a redress scheme. They have to be in a code, and the code provider will adjudicate. And there are various other statutory redress schemes. And then there's what you might call self-regulation. So there's the Advertising Standards Authority. They adjudicate against misleading advertising, but they have a kind of quasi-statutory basis. They're not entirely self-regulatory because they carry out various functions on behalf of Ofcom, but they're a self-regulatory function in the sense that businesses comply with ASA adjudications because it's very difficult not to, rather than because there's a piece of legislation that makes you comply. Right? If you don't comply with the ASA adjudication, then the remedy is that the ASA will complain to trading standards, who may prosecute. And there are many other code schemes which exist where businesses have decided to set up code schemes. They may have an alternative dispute resolution scheme as part of that, and so on. So that's a broad picture of the enforcement landscape in the UK. It's quite complicated. The UK has a very developed economy, and therefore we've got quite a lot of regulators. So we do a lot of regulation. Generally, compliance in the UK is high, but the picture of who does what is quite complicated. Well, what about how do we prioritize? Well, slightly facetiously, I've suggested, well, there's a framework here, do it, diarize it, delegate it, or dump it. That's how you might approach it. That's not how we do things. We apply some enforcement prioritization principles. So we don't do everything. People might complain to us, or there are many things that'd be really useful for us to do. We'd love to do it, but we have limited resources. And so we are driven significantly by what will the impact of our enforcement be. And we do a lot of impact assessment. So it's heartening to hear about impact assessment. Before my little presentation, we have given a commitment to the UK government treasury that we will deliver something like £10 for every £1 of our budget. So we are intending to deliver value to the UK economy, and we carry out impact assessments of the work that we do, so that we can demonstrate that we have given that value back to the UK economy. And usually, actually, we give significantly more. So in recent years, it's been more like £25 for every £1 of our budget. So we deliver an impact of 25 times our budget. It depends on each year, how much it is. So impact is very important for us. But we're also thinking about strategic significance. What's the resourcing picture look like? Do we have resources to do something? Is the work so complicated and involved it's going to require an unreasonable amount of work, or is the impact likely to be so small that it's difficult to justify the resource? Because at the end of the day, it's taxpayers' money that we're spending on enforcement and other work that we do, and therefore it's important that we give good value. And then we also think about risk. So risk in the sense that sometimes enforcement might be an attractive idea, but actually the law is quite unclear. So it may not be the best use of our time to take a business to court because we think we probably will lose in the end, let's say. So we would factor that in as well. So those are the sort of prioritization factors that we take into account. So thinking about that in slightly more concrete terms, given the complicated enforcement landscape, a lot of the time we'll be asking ourselves the question, who is best placed to act? So if we get a complaint about financial services, for example, we might think, well, it's better for the Financial Conduct Authority to look at that. Maybe it's a local matter, or it's routine in a non-compliance, so it's better for trading standards. Importantly, we're often thinking about, can we change how the market operates? Okay, we don't want to become a sector regulator for a sector that doesn't have a regulator. All right, so we're thinking about is there something that we can do that's going to make this market work better and allow us to then exit the enforcement in that market and see how the market develops? Because there's a danger, isn't there, that we become effectively the market regulator, and that's not part of our role to do that. Our role is to make the market work well and then see how it's working, and then if we need to intervene again, back in we go. And we'll also be thinking about, well, what is the best way to achieve change? So we're not constrained just by enforcement. So as I said, we very rarely bring criminal prosecutions. And that's because in our experience, in the markets that we act within and the sorts of issues that we tend to look at, criminal enforcement is not necessarily the best way to achieve change. And that's because criminal enforcement involves punishing somebody for an event which happened in the past, rather than changing how they behave going forwards. Our civil enforcement regime is all about securing change going forwards, and that we find tends to lead to some good outcomes. But it's not even just enforcement in the sense of, what is it, criminal or civil? Sometimes the better way to achieve change is to give guidance, perhaps in a sector where it's unclear how the law should apply. A lot of the law that we use is principles based. For example, it's not specific sets of detailed prohibitions. It's principles based law, like you must not mislead consumers. You know, you have to have terms which are fair. What do these things mean? Well, we try to give guidance which explains what those concepts mean. And sometimes it's not about giving guidance, it's about doing some kind of market study or a call for information to try and understand what is going on in the sector. Or it may be we want to campaign in a sort of not a sort of big campaigning way, but maybe lobbying the government slightly for a change to the law, because we might think the law is unclear. And we could try and enforce it, but actually it'd be better if the government changed the law. For example, so there's a variety of different things that we do to try and achieve change. We have a number of investigation powers. So if we wish to go towards enforcement, these are the sorts of things which we can do. We have wide-ranging enforcement powers. So we have the power to send information notices, which are enforceable by a court order if somebody doesn't comply. We can carry out test purchases. So sometimes those are covert test purchases. We could carry out so-called directed surveillance. We can use so-called covert human intelligence sources. We're empowered to do those things. These are the same sorts of powers that the police have for doing covert investigations. And we have a range of on-site inspection powers. So we can carry out on-notice inspections, without notice inspections, and we can get warrants from a magistrate to go in, and it's an offence of obstruction if the business doesn't cooperate when we're on the premises. So we have broad powers to investigate where necessary. One of the things I haven't included in here is our market study power. So sometimes we do a study of a market, and when we do that, we have comparable information gathering powers, which are in a way even more toothy, if you like, because they carry with them direct fines. If people don't comply with an information notice in a market study or a market investigation, we can fine people quite large sums of money. And that's something which is going to be coming in the consumer side shortly, and I'll talk about that in a moment. Well, if we use the Enterprise Act, what does the Enterprise Act process look like? Well, it's designed to achieve a non-court outcome. That's the idea. The idea is we do an investigation and then we consult with the business. That's where we set out to the business what our concerns are. We say to them, look, these are the concerns that we've got. What are you proposing to do to alleviate our concerns? And they may offer us undertakings. So usually we write to them and we say, here's the concerns and here are the undertakings that we would find satisfactory. And those undertakings might include paying back money to consumers. Nowadays, usually they do. And they include a whole set of changes that we think will make the market work better. And businesses may not want to give us those undertakings. If they don't wish to give them, then the next step for us is to litigate. So we issue court proceedings. In the litigation, we can get urgent orders, we can get final orders, we can take down websites if necessary. But it's all a court-based system. And then assuming we secure an order, then there'll be a process of monitoring compliance. And also, if we get undertakings from a business, we take the compliance of those undertakings very seriously. Unfortunately, at the moment, if a business doesn't comply with undertakings that they've given, there's no consequence as such, there's no fine. But if a business doesn't comply with an order, a court order, then they can be in contempt of court. Officers of the company could go to prison, they could face large fines, and so on. So that's the current system under Part 8 of the Enterprise Act. But looking ahead, we're likely to get some amendments to all of that, some quite radical changes actually to the regime because of the Digital Markets Competition and Consumer Bill, which is currently going through Parliament. And at the moment, that's aiming to change three major aspects. So one is to update our investigation powers to some extent. So we will have the ability to fine people if they don't comply with an information notice that we send them. We'll have the ability, a clear power to send information notices to overseas parties. I mean, we consider we can do this anyway at the moment, but there's going to be greater clarity placed around that. And there will be a clear power to assist overseas enforcers in some circumstances as well. So we would be able to use our investigation powers to assist enforcers overseas. And that's important, isn't it? That enforcers are able to work together in a cross-border context to investigate things. There'll also be some updates to the Part 8 process. So the Part 8 process is going to be rewritten. Much of it is broadly comparable, but importantly, there will be the power for the court to impose civil fines, as well as order compliance, and they'll be able to fine for breaches of undertakings. So if a business has given us an undertaking and they don't comply, not only will we be able to get an order against them, we will also be able to secure a fine for breach. But the most radical change is new powers for the CMA to enforce directly. So through an administrative fining process, we'll be able to find an infringement, not just a court, it'll be the CMA, which will find the infringement. We can then fine the company, order them to pay redress, and direct them to comply with the law in specific ways. And that will be subject to appeal to the High Court. So this is a really radical change, which is going to be coming in. And people may wish to watch the progress of that bill as it goes through Parliament and see how we go about enforcing when we get the powers. There'll be various guidances and rules which we're going to have to work on as well as that process goes on. So that's it. That's the overview of our enforcement regime in the UK. As I said, I haven't really gone into much on what the CMA does. So if people have particular questions on that, then I'm very happy to answer those. But other than that, I will hopefully stop sharing. And if anyone wants to ask a question either in the chat or directly, I'm sure, is there time? I mean, if there isn't, then you can shut me up. Thanks very much for listening.
Thanks, Jason. We really appreciate that. So far, I haven't seen any questions in the chat, but if there are, even if you're not here, we can always forward them to you after the webinar to just get your general feedback and comments on the question. But thank you very much for giving us your time.
Barry, I have one. Barry, I have
Yeah,
one.
go ahead.
Just, well, I
Go
don't even know
ahead,
if it's a
sir.
question or a comment. Jason, thank you for speaking. But I just wanted to pick your brains a bit on if there is anything that's happening in CME concerning airline travel, because we are noticing that prices are going up and the quality of the service being rendered for the price is going down. And there may even be some issues of prices, different prices being offered in different. So perhaps let's use British Airways, for example. British Airways would be giving a particular price to its public in UK and EU. And then for the same trip, a different price will be happening in the CARICOM or elsewhere. So have you had any complaints on that? Are you looking at it, or is it just not yet an issue? But if you did have to look at it, what do you know? For the region, we do think we have an issue with airline travel from the consumer side. So I think that is where our pet peeve is at the current moment.
Well, it's a very interesting question, and something which we've looked at in the past in the context of geo-blocking in the EU context. Now, there was a proposal which indeed became law to prohibit geo-blocking in many contexts, not travel, I think, actually. And this is based on the idea in the EU that, you know, it's a single market and therefore you should be able to get the same price wherever you are in the market. And I think we don't really regard differential pricing as such as a consumer infringement issue. It may sometimes be a symptom of weak competition, but it may also not. It may be a sign of the market working well, and that's because it tends to be the case that firms do offer different prices to different consumers. They seek to identify where people's pricing points are and to maximize profit in a way which means that they can both offer good deals to some consumers and, you know, offer a competitive price to other consumers, which those consumers are willing to pay. And I think if you're on the receiving end of higher prices, that can often feel quite unfair, but it isn't necessarily something that we would say is a consumer infringement. It might sometimes be an indication of the market not working well for some reason. So usually you tend to find higher prices like that, I think, where you've got weak competition. So if there's fewer carriers operating from a particular part of the Caribbean, then it may be that they would charge higher prices because you've got limited choice. And sometimes that's the kind of thing which we could look at if it were happening in the UK in the context of a market investigation. And in those circumstances, sometimes we tell people to sell infrastructure, or we might impose some kind of price cap or something like that to make the market work well. But it wouldn't be a consumer infringement, generally speaking, as long as you're not being misled or the terms of the contract are unfair. So, you know, slightly different perspective, perhaps, I think, that we take than maybe that you take, but happy to discuss further
but I
either
think
now or later.
you did hit the nail on the head, because we do think that it is a demand side issue. It is something that arises from market failure because of the reduced number of suppliers. But at the same time, there being a market failure, there will be a consumer impact as well. So thank you very much. That is it for me, Barry.
Thank you, Edie and Jason. So now we're going to invite Mr. Stephen Kamukama, who is the Manager, Consumer Welfare Advocacy Division of the COMESA Competition Commission. That's the Competition Commission for Eastern and Southern Africa, to present on the topic of enforcement of consumer rights in a digital environment, a COMESA perspective.
Thank you
Mr.
so much.
Kamukama?
Thank you so much. I hope you are you're able to see the slide.
Yes, we're seeing the slide and we're hearing you clearly.
Thank you so much. Yeah, we are happy and glad and appreciative for CARICOM to have invited us to participate in this webinar and to present our COMESA's experience in enforcing rights in digital environment. So as part of what we are going to look at from the COMESA Competition Commission perspective, we'll be sharing on the mandate of the COMESA Competition Commission and the provisions that are in our law. We'll look at the consumer protection in the digital era. We'll look at the benefits. We'll look at the rights, and then look at the cases that we have handled, and then also look at the emerging issues. So the COMESA Competition Commission is established under Article 6 of the COMESA Competition Regulations, and that is pursuant to Article 55 of the treaty establishing the Common Market for Eastern and Southern Africa, which we call COMESA. The Commission is mandated to enforce, promote, and encourage competition by preventing restrictive business practices and other conducts that deter efficient operation of markets, as well as protect consumers. Our member states are 21, and the list has been provided for those who would want to see the member states of COMESA. So the COMESA competition regulations under Part 5, they prohibit a number of conducts which are considered to be violating consumer rights. One of them is false and misleading representation.
Excuse me, Mr. Kabukami.
Yes.
Mr. Kabukami, yes, I just wanted to let you know that your slides aren't moving. So we're still
They are
on
not
your title slide. Yes. Thank you.
Oh. Okay.
Great. Thank you.
Okay. Thanks. So under Article 5, under Part 5 of the COMESA competition regulations, the law prohibits a number of conducts which are considered to be violating consumer rights, and these include false and misleading representation and unconscionable conduct, both for consumers and for business persons, product safety, again on both the product safety for goods and then product information. In this case, we also have a situation where we can recall goods, especially for defective goods. We recall them from the market. And when a supplier supplies the goods into the market, the manufacturer is the primary responsible person, liable person, but in the event that we are not able to trace the manufacturer, then whoever supplied the product would be liable. Now, the regulations apply to both online and offline conducts. At the moment, we are currently reviewing the law because of the emerging issues, some of which are in the digital area, and we see that there are some gaps, so we are now amending the law. Now, the law applies to the effect it applies that effect which affects two or more member states. So when we are going to use the regional law, we have to look at the effect which affects two or more member states. The member states have their own national laws, but there are conducts which have cross-border effects. And when a matter includes or relates to an issue which has a cross-border effect, the regional law applies. And for now, this regional law applies to all the 21 member states who use this one overall law, which handles competition matters and consumer protection matters. For as long as there is a cross-border effect, then this national regional law will apply. So we go to e-commerce. I think this, I will not spend a lot of time because it's been discussed so much since we started. But what has so far been said, we know that e-commerce helps us, especially online platforms, to quickly get the goods online. We can get as much variety online. We are able to compare products and prices so easily, which sometimes is very difficult for online products, for offline products. We have several modes of payments, which also allow us to even sit at home and be able to pay. And then for the people, the side of the suppliers, it is easier for them to even store as many products because for them they are just putting on the platform, they don't need space like the one required by the offline suppliers. Now, because of these advantages, we notice that these digital platforms are growing, and right now we have about 12 to 24 million sites that are actually providing e-commerce services. And of those, we have about 57% worldwide consumers who purchase goods overseas. And also some of that, we have 55.5 from Africa and about 54.6 from Latin America. So you can see that the business online is increasing. And also we have the sales as they have been growing. We can see that since 2021, it has moved from $5.2 trillion currently to around 6.3, and estimated to going to around $8.1 trillion. So this now is a growing business. But then, while it's a growing business, it also has consumer concerns. As consumers, there are a number of violations that are happening online, which affect consumers. And some of them, again, goes quicker on this because they have been covered in one way or another. But you find that it's very difficult to verify goods online. We buy something online, it comes when it is either unsafe, defective, or it's a counterfeit. The online platforms don't have clear redress mechanisms. Sometimes the interface that there's no personal interface. You are only going to use only the email or an online form, but you will not be able to speak to anybody. And that also causes a problem for the consumer. The consumer data security has been discussed, but also we have serious areas relating to liability disclaimers and unfavorable terms, and then again unfavorable return policies, whereby the consumer, in the event that they need to, they are aggrieved and they want to take action, it becomes very difficult to take the action because of these unfavorable terms. One other challenge that the consumers have is that, again, within the terms and conditions, it would be specified that the law, the applicable law, is the law in the overseas or in another jurisdiction. And then in that case, it becomes very difficult for a consumer to take action because the applicable law governing the contract is already in the overseas in another jurisdiction. Even then, when they want to return the goods, then they also have a challenge because there's no local presence of the supplier. Aspects relating to child protection, these are serious areas, and of recent we hear even where the children are being bullied and they are being harassed. And we are even beginning to hear areas where, in some countries, where people are beginning to commit suicide because of the harassment that takes place online. So we also have digital payment challenges, and that now also becomes a problem. You pay to the supplier and the money does not reach. The supplier will not give you the money, but at the same time, also not get back the money which you paid. So these are challenges that are affecting consumers. There are many more, but I just summarized some of these. Now, all these challenges we are looking at are affecting consumer rights. They are affecting consumer rights to health, the right to safety, the rights to accurate information, the right to choose, the right to fair treatment, the right to redress, the right to have your personal data protected. These are fundamental human rights and consumer rights, and they are violated online by platform operators, by the suppliers who supply through the platforms, and sometimes the consumers find themselves with a challenge to have their concerns addressed. Now, if you look at this, you will see we have the suppliers supply through the platform, and the platform supplies to the consumer. But here you can see that on the platform is the one marketing the product. It is the one which receives the orders. It is the one which receives the payments. It receipts the payment and delivers the product to the consumer. But along the way, the consumer would have made a payment which may have gone either through the bank to the platform, or which may have gone through a telecom company which provides digital payment services. But when the transaction goes wrong, who then is liable in this whole process? When the platform is not able to deliver the product, is it the supplier that is liable? Is it the bank which had received the money? Is it the telecom company? When the supplier is claiming that he has not received the money, and therefore he cannot deliver, what do you do when actually the platform that was provided for purposes of payment was provided by the platform, but then that platform channels the money through the bank? So on the account of the platform owner, the money is not there. So the platform is saying, no, we did not receive the money. But at the same time, for you, the money has been spent and you expect to receive the goods, but you cannot receive the goods because the platform claims they did not receive the money. The same thing goes to the supplier. When the goods which come from the supplier come when either they are unsafe, they are not necessarily what you ordered, they fall short of what you ordered, whom do you blame? Is it the platform? Is it the supplier? And then we have all these challenges that come through online platforms. So what have we done? We've been able to handle at least 2 cases. One of them involved an online platform which operates within the COMESA region. It actually operates in Kenya, Uganda, Egypt, and Tunisia. And this platform sells goods, but at the same time delivers goods which are sold by the third parties, other suppliers. So it sells its own goods and also sells goods which are delivered by other suppliers. Now, on its platform, it was indicating that first it did not show its own legal name. And it was very difficult for consumers to be able to take action in case they were aggrieved, because the platform was not indicating its own legal name. The other issue that it had on its platform, it did not have a clear dispute resolution mechanism. It only had a form where you send in a complaint, but whether they handle or they respond back to you, that was left to them. If they ignore you, there's nothing else you could do, because only the platform had a form, and it is only that form that you could fill in order to complain, and nothing else. And the platform indicated in its terms and conditions that it does not guarantee completeness or accuracy of the information provided on its platform. So even the products which are on the platform, the information accompanying those products, according to what they were saying, is that they cannot guarantee the accuracy of that information. Now, then how would the consumer rely? How would the consumer make a decision, an informed decision, relying on this information, which the platform itself is saying it's not, may not be accurate? And the other thing that the company did was to disclaim that they are not liable for any condition of the goods that will be purchased through that platform. And now, again, it was very difficult for consumers to know, in the event that they have a problem with the good, whom do they take to court? So now we found these provisions on the platform of Jumia. The company is called Jumia. We found them unfair. We found them unconscionable, and we intervened. The company accepted to address the concerns, and it amended its terms and conditions. We also had another case where we had a company which is also operating online within the common market. And for that company, it said that it does not allow consumers to return goods purchased through their website if they are marked shipped from overseas. So the supplier is this company, which is called Kalimali. It operates an online platform. The consumer goes online on the online platform, buys the goods. They are delivered, marked, shipped from overseas. But as soon as there is a problem with the product, the consumer cannot take back this product, because the terms and conditions indicate that a good marked shipped from overseas cannot be returned. And then that means that the consumer, of course, will make a loss and will not be able to get any redress. So again, we intervened, and the company, Karimali, accepted to address this problem. So what are the emerging issues? We have a number of them. Some of them have been mentioned, especially like dark patterns, which are now coming up, whereby websites, social media platform, and any other online applications, they use tricks to trick consumers into taking services they do not intend through misleading tactics. Some of these tactics include obstruction. You find that you want to cancel either a pop-up or a web browser. You want to cancel, you cannot cancel. You have to keep reading what is in front of you, even when you want to cancel. You may want to cancel the transaction, but you cannot cancel the transaction. You are shopping, and then as you put your goods which you have selected into the shopping cart, some other goods end up there in the shopping cart, even when you have not included them there, which we call sneaking. You have an interface which is hiding some information, and some of it is pre-selected for you. Because it's pre-selected, you are ending up having to choose what you did not want to choose because of pre-selection, and that is interference. We have forced actions which go on. We have where you subscribe to software, to some service, but when you want to stop the subscription, you find you have no option. The application is not giving you a chance to be able to unsubscribe. So it's like you are forced to continue subscribing. We have aspects which limit price comparison. On the website, on the internet, there are so many softwares and applications which allow price comparisons, which would help you to see which product is cheap and buy that one. But because of price comparison limitations, you are not allowed, and then you miss buying a cheap product. So areas where we have some hidden costs, disguised adverts, bait and switch elements, where they will invite you to come in advertising a cheap product, but when you come in, when you are starting to buy, then they present you with a very highly priced product. And then there's forced continuity, which is relates to continued subscribing. You get a software. It says it's for free trial arrangement, and then for you now subscribe on the basis of free trial arrangement. But before you know it, you discover that when the period ends, they continue charging you even when you are only subscribed only for free trial arrangement. So these are some of the challenges happening relating to dark patterns. Others are scams, which have been mentioned so much in the earlier sessions. And these are serious concerns that are affecting consumers. Now, what then happens with such concerns? Because what we are not seeing is that some of these concerns are very, very, very hard to recognize. We cannot use the traditional measures we have used to detect conducts in the market which violate consumers. These ones require additional resources. They require more experts. They also require technology that can be able to identify such conducts and also be able to address them. The traditional consumer protection authorities did not necessarily use like psychologists. Now, IT experts, sociologists. For now, it is now becoming so important that such authorities start now employing these experts to be able to identify and address such concerns. What are we doing within the commission, the Commercial Competition Commission? We are trying to enhance collaboration with our member states as far as sharing information is concerned, also in terms of benchmarking. So we collaborate with member states, we collaborate with other competition authorities in other jurisdictions, such as the US, CARICOM, UK, Australia, European Union, to see that we share information and benchmark on how they are doing their work. And we are able to also now incorporate some of those strategies they have in our own plans. We try to build the capacity of the member states through trainings and awareness programs. We do advocacy and education programs to consumers, and we are now looking at how we can apply technological innovations to be able to keep up with the changing technologies and changing consumer violations driven by technologies. Thank you so much. I think I can now stop here.
Barry, I wanted to
Thank you,
know if
Mr.
I wanted to know if he's okay to stay on for questions after, or if he wanted his questions now, because I'm just noting the time, and we've got 3 more presentations.
If there is a question, I could answer it now.
Okay, so participants, are there any particular questions that you have for Mr. Kamukama before he goes, given the time difference? I'm not seeing anything in the chat as yet.
We're catching them at the lunch hour. So if we have any questions coming through, we will share them with you. But we do hope that you guys can stay on to hear the rest of the session. Thank you very much, Barry.
You're welcome.
All right, thank you. So colleagues, now our next presenter should be Miss Sasha Gay Russell, Legal Officer of the Consumer Affairs Commission of Jamaica, and she'll be presenting on the legal framework and experience of consumer enforcement in Jamaica. Ms. Russell?
Hi, good afternoon, Barry. Good afternoon, Chairman, distinguished speakers, guests. Thank you for this opportunity to do this presentation. I'm just going to share my screen. You can let me know when you're seeing it.
We are seeing your screen. Go ahead.
All right, so I'm just going to do a brief presentation on the administrative and legal framework for redress and enforcement in Jamaica. Just a quick summary of the work of the CAC, or who we are. The Consumer Affairs Commission of Jamaica, we're a government agency, and we operate under the Ministry of Industry, Investment and Commerce.
Your slides haven't changed?
Oh, that's fine.
Still saying
yeah.
Okay, all right.
Yeah, that's fine. That's fine. Thanks, Barry. So we operate under the Ministry of Industry, Investment of Commerce and Commerce. The legislation that established the Consumer Affairs Commission of Jamaica is the 2005 Consumer Protection Act. And that act is what gives us the jurisdiction to do what we do in terms of investigating complaints and also conducting market research, amongst our other duties. The act was actually amended in 2012, and this amendment was primarily to establish the Consumer Protection Tribunal. There are 5 main functions of the Consumer Affairs Commission. We investigate breaches of the Consumer Protection Act. We promote other consumer organizations, such as the National Consumers League of Jamaica, otherwise known as the NCL. This body is a non-government organization that the CAC supports financially, and we provide other resources to them as well to assist with their advocacy on consumer rights and representation. We collect consumer information, and we actually have a research unit, and some of the functions of the research unit are price monitoring of critical goods and services. We do market surveillance, for example, of stores, supermarkets, petrol stations, to see if they're in compliance with the Consumer Protection Act. We conduct customer satisfaction surveys, and we also spearhead policies, consumer policies and standards. We do consumer education at the CAC as well. And this is done through different presentations through webinars. We attend expos. We present to children in schools, churches. We also meet with vendors and different service providers in an effort to educate them on the provisions of our legislation with the primary act, which is the Consumer Protection Act. And finally, dispute resolution. And this role is primarily carried out by the complaints officers. There's a complaint unit. And what they do is that they use mediation to resolve disputes between consumers and vendors. And we try to get the parties to meet to see if we can come to some sort of compromise between the parties for the complaint that was filed by the consumer. Briefly going to touch on how the Consumer Affairs Commission investigates breaches of the CPA. We encourage consumers to first speak with the vendor to try and resolve the dispute. And we encourage consumers to assemble all the facts, as they have a better chance of gaining redress if they have all their documents together, which would include their receipts. And if there's a contract, a written agreement, we ask them to provide that as well. And any other document that is relating to their complaint. If the dispute is not resolved at that stage, then we encourage consumers to file their complaint with the Consumer Affairs Commission for us to investigate the complaint. We actually have some partners, well, a number of other government organizations and institutions that we work with to assist us in our investigations or to gain information based on their experience. For example, the Bureau of Standards, the National Compliance Regulatory Authority. If we have a complaint where we have to send a sample for testing to see if the item, it might be concrete, whatever it is, if it's at a certain standard, we'll send it to the NCRA and ask for a report on the sample that we collected. We also liaise with the Fair Trading Commission on the complaints that we have. Sometimes we refer complaints to them and vice versa. And as a part of the investigation process, what the complaints officers will do is that they'll make copies of the documents in the possession of the consumer that is related to the complaint, so their receipts, their contracts, etc. They'll peruse those and then they'll make contact with the vendor to basically give them information on the complaint that was filed and ask them if what happened, get their side of the story. And based on the information that is provided to us by the vendor, the complaints officer will be able to determine whether or not the act was breached. Once that determination is made, the officer will formally write to the vendor and ask them for redress, and they will quote the section of the act that was breached. If redress is not provided, then the matter may be referred to the Consumer Protection Tribunal. And what is key to note here is that the matter may be referred by either party. So a consumer can refer a matter to the tribunal if where a vendor is not providing them with redress. And a vendor can refer a matter to the tribunal if they want a determination on whether or not the CPA was actually breached. How does the Consumer Affairs Commission of Jamaica assist or help consumers and vendors in dispute resolution? All right, so mediation is conducted by complaints officers. And what this actually includes is arranging meetings between vendors and consumers. If successful, the consumer and vendor will enter into a formal arrangement to settle the dispute. However, if the dispute is not settled after mediation is conducted, then as I had stated before, either the consumer or the vendor may take the matter to the Consumer Protection Tribunal for determination to be made. I just want to briefly touch on some achievements of the Commission from April 2022 to March 2023. I'm going to go through these quickly. In terms of outreach activities, we spoke earlier about the consumer education, what our officers actually do here in terms of speaking to consumers through seminars and expos. 62,508 consumers were directly sensitized. In terms of complaints handled during that period, 1,348 complaints were handled with our 80% resolution rate, with 1,081 of those complaints being actually resolved. Advice or information provided, 444 consumer requests for advice were fulfilled. And this is really where consumers contact the CAC to gain more information on their rights and their responsibilities, or to ask us questions about the Consumer Protection Act. In terms of money secured for the period, we secured 49,700,000 Jamaican dollars on behalf of aggrieved consumers. Media exposures, 5,653 total exposures were secured during that period. 28 press surveys were conducted. And I also want to touch on the National Consumer Policy. This policy was really spearheaded by our research unit. What the policy aims to do is to really create a framework that promotes cooperation between the government and the business community. And going further, the policy aims to equip staff of consumer protection entities such as the Commission and the National Consumers League with the knowledge and skills required to deliver quality services to the consumers that we serve. I'm going to briefly discuss the Consumer Protection Act. Consumer Protection Tribunal. This is a quasi-judicial body, as it can, amongst other things, make binding decisions. So it has similar authority to that of a court. However, a court may review a decision arising from the tribunal. So a decision can be challenged via judicial review. And this will really happen if a consumer or a vendor is of the view that the tribunal did not fairly adjudicate or handle the complaint that was filed before it. If there was any procedural impropriety or anything like that in how the tribunal handled the matter, then the consumer or vendor may seek to have that decision file a judicial review application before the Supreme Court for that to be looked at and determined. The law actually requires that hearings should be placed before an independent and impartial tribunal. Therefore, it is important for us to note that the functions and the roles of the Consumer Protection Tribunal is separate and distinct from the functions of the Consumer Affairs Commission. So there are two separate and distinct entities that were established under the Consumer Protection Act. Currently, the tribunal has 7 members. However, when there are hearings, 3 members will sit on the panel. I just want to briefly touch on new matters which have been filed before the courts, tribunal, and the Supreme Court, tribunal, and parish court over a 5-year period. So these are new matters which were filed. 2 cases were filed before the Supreme Court. 1 case was actually settled after the case management hearing, and the other matter was an application for judicial review of a decision made by the tribunal, and that matter was subsequently settled. 3 cases were filed before the tribunal, and the tribunal granted decisions in all 3 of those matters. And in relation to the parish court, 2 cases were filed in which the CSE were involved in those cases, and that's for the criminal division of the parish court, and both cases are ongoing. And I just want to provide some more information here in relation to our involvement in these 2 cases. The CAC often provides support to consumers who have been victims of fraud through their consumer purchases, in that we refer persons to the fraud squad, which is actually a unit of the Jamaica Constabulary Force, and the matters are investigated and then placed before the parish court, formerly called the Resident Magistrates Court. The director of that business, or the business owner, is charged, and the matter goes through the routine prosecution process. The police may charge the business owner or the director under the CPA, which is the Consumer Protection Act. However, they may charge them, for example, for fraudulent conversion under the Larceny Act, where, for example, a vendor takes money from a consumer to provide goods and services and then does not in fact deliver the item. So that's an example of how we work with the team at the fraud squad to prosecute vendors who engage in that kind of activity and do not give consumers what they have in fact paid for. Want to briefly touch on some challenges that we experience in enforcement. So enforcement of tribunal judgments. Section 44G of the Consumer Protection Act details what happens when a vendor fails to comply with an order of the tribunal. And it's summarized here. It says, Section 44G, any person who fails to comply with an order of the tribunal commits an offense and is liable on summary conviction before a resident magistrates, now called parish court, to a fine not exceeding $2 million or to imprisonment for a term not exceeding 2 years, or to both such fine and imprisonment. So essentially, what is happening here is, if the tribunal makes an order and a vendor does not comply with the order, the director may be placed before the parish court, prosecuted, and charged a fine. The fine, of course, is payable to the government if the person is convicted. However, this is not necessarily desirable because it lengthens the amount of time before the consumer is provided with redress. And as my colleague stated earlier, Mr. Freeman, litigation is not always necessarily the best option. So we really have to, after we've executed and done all other avenues, and the consumer still has not been provided with redress, that we may try to go in this direction. Another challenge that is faced is enforcement of parish court decisions and even Supreme Court decisions, where we find that limited liability companies have no access to seize, so they don't satisfy the judgment of the court, and there are no access to seize and sell. And so you find yourself having to go the direction of instituting garnishee proceedings or insolvency proceedings against the company, undesirable length of time that's going to take. Or if you're brave enough, you might seek to try and pierce the corporate veil of the company. But at the end of the day, the main goal here is really to claim redress on behalf of the consumer, to get them their refund, to get them your replacement or repair, whatever it is that is best for the consumer who has suffered. That is really the goal here. It's not to litigate for years and years, and it's not to drag out the whole thing. But if we have to, these are other avenues which can be considered. This is the end of my presentation. I want to thank you for listening. I'm not sure if there are any questions, but thank you. Barry, back to you. Thanks.
Thank you, Sasha, for that most informative discussion and putting out your experience of how you enforce your Consumer Protection Act and the fact that you have to work with other agencies in order to provide redress for consumers in Jamaica. So now,
Thank you.
Now to our next presenter, we have Cecilia Melville, who is the Deputy Program Manager of the Directorate for Economic Innovation and Development at the CARICOM Secretariat, who is speaking on a new topic for most of us, which is the development of a consumer financial protection policy, model bill, and regulations for the CSME. Cecilia, the floor is yours.
Good afternoon. Well, good morning, good afternoon, and good evening to our participants. I am now trying to share my screen. Just give me a minute. Barry, if I'm not able to, I would appreciate you putting it up, but let me just try.
Okay, let me try and get your presentation ready, just in case.
Just let Sasha just pull off yours, stop sharing yours, and then Cecilia will be able to put up his. Sasha, pull off your presentation. Stay stop share. Right, good, thanks.
I'm seeing mine. I can get it in. Okay. Yes.
Yes, we're seeing it.
Okay. I wish to thank the CARICOM Competition Commission for this opportunity to share some information on the important work that we are doing at the CARICOM Secretariat. The work is focused on strengthening the legal and regulatory framework for the regional financial services sector, but in particular, it looks at developing a financial consumer protection regime for member states. I mentioned that the work is being led by the CARICOM Secretariat because I want to emphasize that it has been a collaborative effort between the Secretariat and member states. We have received participation from representatives of both the public and private sectors, as well as regional institutions such as the CCC in undertaking this work. MENS SPRL, the consultants, have done excellent work in producing the draft FCP framework. And this framework encompasses a draft FCP policy, a model FCP bill, and regulations, as well as explanatory notes. Just in passing, I want to mention that the work that was undertaken has been funded by the 11th EDF strengthening framework for CARICOM integration and cooperation. Before you is the outline. I'm going to go through quickly because I know we are running out of time. Of course, during the Q&A, any questions the participants want to raise, I will address. Barry mentioned that this is a relatively new area for the region, but of course, it has been established as a regulatory concern since 2011 and actually before that. And the interest in it has been fueled mainly by the global financial crisis. I have before you here a definition. Financial consumer protection refers to the laws, the regulations, and other measures generally designed to ensure fair and responsible treatment of financial consumers in their purchase and use of financial products and services, and in their dealings with financial services providers. We are recommending that the CARICOM member states align their domestic regimes with the above definition. The rationale for the regional framework. I believe it's Ms. Ramsuda.
Your slide, I don't think your slide deck is moving.
Not moving. Why is that? Just a minute.
No, because you spoke about the definition, but we're still seeing the original cover slide.
Oh, okay. 1 minute. Let me see what is happening here. Are you seeing the rationale for the CARICOM framework?
No, I'm still seeing the original cover slide. Okay, so the slide deck is moving now.
You need to press a slide share at the left-hand side of the screen.
Sorry, on the left-hand side. Are you seeing it now?
Right at the bottom, there's a slide 2 to 19. If you press a little arrow, and it just moves your slides.
Okay, I'm not sure what is happening, but I was able to move the slide deck along. So
okay,
I'm not sure
let's see if this is that working? Which slide are you seeing?
The CARICOM perspective on financial consumer protection and the definition given by the G20 OECD.
Are you seeing the rationale?
No.
Okay, so something is wrong on my side because I am seeing it moving on my side. Barry, can you manipulate the slide?
Okay.
Okay. I think we all
the
can.
rationale.
Yeah, I just moved the slide forward for you. Yeah,
okay,
I just moved it forward.
Yeah, so let Romel do it. Yeah.
All right. Okay, so Romel, I am on the rationale for the CARICOM financial consumer protection framework. And yes, I was emphasizing that some of the justifications are well known to all of us in the region. There has been growing concern, public concern about the unfair practices of financial services providers, which I will refer to as FSPs in the community. In addition to that, there has been a global shift in policy focus. In the past, prudential supervision has been the centerpiece of financial sector regulation, but there has also been growing concern with financial consumer protection as well. And a natural reason for the work that we're doing is that in the region, the market conduct, not regulations, but the market conduct regimes that exist are based on voluntary codes of conduct, and therefore they are not legally enforceable. To the extent that you have legal and regulatory provisions in many of the financial sector regulation and also in the general consumer protection regulation, as was mentioned before, some are outdated and the framework is very fragmented. So this can lead to regulatory arbitrage and also to gaps in the protection that's offered to financial consumers. We would acknowledge too that the very nature of financial services lead to the need for a special regime for the protection of persons utilizing these services. So the focus is to establish a common regulatory regime for market conduct of FSP and consumer protection. And the underlying rationale is to operationalize the CARICOM single market and economy, and of course, an integrated financial services sector. Next slide. The process, consultative process. The consultancy that was undertaken began in May 2021 and concluded in May 2023. It was a very broad consultative process with participation from public and private sector persons and institutions. I've listed here the various forms of outreach and consultation that occurred. There was an introductory webinar, as well as questionnaires, very detailed interview sessions with the various regulators and financial supervisors, as well as consumer protection agencies. That was well received. One of the things that struck me in these sessions is that persons gave their regulatory experience as well as their personal experience navigating the financial services sector and their engagement with their financial service providers. The highlight of the consultative process was, was 2 regional consultations which were held. One held in September 2022 and the other held in March 2023. Those consultations allowed us to interrogate the work that was produced by the consultants. In the first instance, the draft financial consumer policy. And in March 2023, we looked at the model bill and the proposals for the model bill and regulations. The earlier speakers mentioned the kind of concerns that have emerged with respect to consumers' purchase of goods and services. Some of them are very much relevant to the financial services sector, but here I have listed some of the peculiar concerns to the financial services sector that was revealed in the situational analysis. General consumer concerns in CARICOM that emerged were poor customer service. Of course, that runs the gamut from lack of training of staff who are attending to clients to treatment of vulnerable groups, long queues, delays, the inability to request special consideration for hardship applications, etc. Also misleading advertising. This is in respect to the interest rates that are applied, even the calculation of these interest rates, and whether you are notified as to the interest rate that applies to the loans. Product comparisons, which is the inability to compare products across the financial institutions. Challenges with account opening and closing. Now, while the AML CFT requirements have made this process more complicated, the issue is not just that the information is being requested. Sometimes the information that is being requested is not readily available to the would-be client. In many instances, young adults may not have the requested information, and this may lead to either protracted account opening, or maybe they are not even informed properly as to what is required of them. Credit refusal, denial of loans, etc., without proper notification or advice to the client as to why they are unable to receive a loan. I mentioned before interest rates and their calculations. Also fees and charges. This is a grave concern because fees and charges are also imposed on low account balances. And we mentioned before vulnerable consumers. This can create a lot of hardship and financial distress for vulnerable consumers. Fraud is a perennial problem in the system. And there isn't always a a clear course or clear avenue for customer recourse when fraud occurs. There are sometimes delays in compensation as the financial institution seeks to work through its investigation. The complaints process is usually murky. In some instances, it's unclear, inefficient, or one may not even get on to a person. They may have to deal with automated voice responses. And of course, where there's a dispute as to how a matter is handled, this may not be readily available to the clients of financial institutions. Barry, could you move on? Hello?
Yes, I'm moving it.
Hello?
So we're
Yeah,
now
it's
to the
on international principles.
Thanks. Okay, that's I've just put up that slide so the meeting can see the various principles that have informed the work to develop a common FCP framework in the region. Very extensive. What I will note on that slide is that the G20 OECD principles that were initially published in 2011, they have now been updated as of December 2022. So there are now 12 principles instead of 10. They are cross-cutting themes dealing with digitalization and technological advancement, which has emerged as a major concern with many of the speakers here today. Financial well-being, which is zeroing specifically on the welfare of clients of financial institutions and how engagement with these financial institutions may impact their current state of well-being as well as their future state of well-being, and also the issue of sustainable finance. The next slide highlights some of the key principles regulating market conduct. I'm not going to go through in detail. Suffice it to say, it covers many of the issues that are relevant to general consumer protection. It simply imposes the obligations on financial institutions to meet these requirements. Data protection and privacy has been discussed in detail, and so too the need for an internal complaint resolution mechanism as well as the alternative dispute resolution mechanism. So I'm going to go on to a little more detail on the FCP framework. The purpose of the FCP framework. Well, first, it seeks to promote the establishment of a modern, harmonized financial consumer protection framework for CARICOM member states, which is consistent with international best practices and which promotes transparency, efficiency, and the deepening of retail financial markets in the community. And secondly, it is a key element of CARICOM's financial sector modernization agenda, supporting the CARICOM single market and economy. The framework is based on, it adopts a principles-based approach and a rules-based approach. In essence, the principles are based on the international standards, but they are now enforceable. No longer is it going to be voluntary. Its application is going to be voluntary, as has occurred in the instances with the Code of Conduct. The rights and obligations articulated in the policy are therefore legally enforceable. And given that it's a community policy and a community framework, member states will be obliged to adopt the FCP framework once it's approved by the relevant organs. In this case, it would be the Council for Finance and Planning, as well as the Legal Affairs Committee. The next slide gives the scope and applicability of the framework. We have defined a protected consumer as a natural person who obtains a financial product or service from a financial service provider for any purpose, personal or business, or may consider doing so, and includes a natural person on whose behalf a financial product or service is obtained or may be considered. The definition is deliberately broad. It includes Harry, Barry, I'm seeing someone mentioning they're still seeing the slide on rational.
I'm not sure what is happening because right now on
But
my screen I'm seeing
slide 12.
slide 30.
Yes,
Okay,
I'm
from
seeing slide 12.
Okay, I think
I-
I think there's some way that it has been shared that it her slide is stuck on slide 4.
Okay.
So don't sync. Each person at the bottom of your screen, I think that's what Anne-Marie was trying to say earlier. At the left hand of your screen, you're going to see 2 little arrows and 13 out of 19 or 4 out of 19. Go ahead and move the forward arrow yourself to slide 13. I think we should all be able to do it and we should be fine. So as she says what she's on, you find the slide, you just move the slide yourself. Thank you.
All right. Thanks. Thanks.
Can you
Nikki.
confirm what slide we're on now, please?
I'm on slide 13.
Thank
13.
you.
Sorry about that. My apologies. I think what I did, I shared while the other person's screen was on, and I may have done something strange. So I'm going to stop sharing on my side and leave it to Barry.
No.
Oh, does
All right.
that makes it
Okay.
worse, or
I
is
will
it
share.
better for everybody?
share.
Is it worse?
That's worse. That's worse.
Okay. Okay. Sorry.
No. I will share from my end. It's not a
Okay,
problem.
Barry. All right. Sorry about that.
Yes.
My
I will share
apologies.
from my end.
Let's
So let
continue.
me just slideshow. Uh,
Okay, while Barry shared, I'm just going to explain a bit about the broadening of the scope and why this piece of work is revolutionary for the region. Apart from
okay,
moving us to
everyone can see the slide.
yes, on my end, yes. Yes, okay. So this work is revolutionary in the sense that one, it's a legally enforceable code of conduct for FSPs, financial services providers, and it establishes in law the rights of the financial consumer. In addition, it allows for the expansion of the definition of consumer to include small businesses because it says any person who uses the service, any natural person who uses the financial service obtains it for personal or business use. And it does also allow the inclusion of class of persons, because it says on whose behalf. The model legal framework is also activities-based versus institutions-based. That allows it to treat with small and large service providers who engage in the same activity and regulate them, or I should say subject them to the same level playing field in respect to regulation. It also speaks to current and future services, products and services. Therefore, it's very comprehensive. However, it does provide for exemptions to be granted by the minister with responsibility for FSPs, sorry, for FCPs. The next slide just gives you a clear idea of all the services. Okay, yeah, there was covered financial products and services before that one. Barry, could you go back to 12? Sorry, not 12. Sorry, we are on 14. Stay on 14. Okay, so what are the proposed strategies and measures to implement this framework? Well, strategy 1 speaks to establishing a common best practice framework. This is what I have been discussing. And strategy 2 looks at improving the conduct of FSPs in their treatment of financial consumers. What will be required there is that they will have to implement all of the provisions regarding the regulation of market conduct and also be obliged to consider the financial well-being of their clients in their design, marketing, and provision of financial products and services. Strategy 3 speaks to the obligation to educate and sensitize consumers about their rights and means of recourse. There's also implicit in that sensitizing or educating customers about financial literacy program and ensuring that they are aware of the risks of the products in which the product they utilize or consume. Strategy 4, ensure the effective implementation of the FCP framework by member states. Again, I mentioned that there is this obligation for the member states to implement the community policy and the model bill. You can move to the next slide. The measures will provide for the rights of consumers in the financial sector. It will provide for the compliance obligations of the FSPs, provide for stringent enforcement and penalty regimes. We know that for any system to work, enforcement must be credible and it must be robust, and the penalties must be a deterrent. So we do recognize the need for balance between innovation and regulation. But in order for compliance to be credible, or for the, I should say, for the regime to be credible and for compliance to happen, you must have enforcement. Next, the measures will also support the development of the integrated financial sector. It's very important that we recognize all of this is for the purpose of creating an integrated internal market for financial services within the community. There was discussion before about the diversity and what is happening in the region and how difficult that makes the cost of doing business and the ease of doing business. So there is the need for that harmonization that is happening. And I take note that Ms. Ramsundara mentioned that there's an absence of a super regulatory authority. And therefore, a lot of what we do is through consensus. So the starting point has to be the harmonization. It also provides a legal foundation for cooperating on cross-border matters. The next slide, functions of the financial supervisor, sorry, the FCP supervisor. I want to point out that in our discussions, we did not identify a single regulator as being the FCP supervisor. We did not indicate a preference for a model. It can be the Twin Peaks model, where you have both a financial market conduct authority and a prudential regulator, or it can be the, you can utilize existing consumer protection authorities as well as financial supervisors who will now have the added responsibility of being an FCP supervisor. The functions are to promote fair and equitable treatment of consumers, promote responsible practices by the FSPs, including responsible lending, to monitor the business conduct of FSPs, develop the financial capability of consumers and promote public education on financial matters, educate the public about the benefits and risk of financial products and services, and of course, to collect market data and do the various analysis and mystery shopping, etc., to ensure that consumers are protected. And finally, the FCP supervisors will advise the minister with responsibility for FCP matters. Some of the enforcement powers that will be required. The supervisory agency or FCP supervisor should be able to issue binding directions, impose administrative penalties, issue cease and desist orders, make orders for the withdrawal or amendment of a product or service, apply to a court for a range of orders, including injunctions, freezing of property, etc., sanctions, etc., take action to seek compensation on behalf of a consumer or a class of consumers. And that was one of the revolutionary recommendations I mentioned, action on behalf of a class of consumers. That will be very useful in our context, given the bargaining strength and the market power of the FSPs that operate in the region. Enter into court enforceable undertakings with FSPs. Finally, the benefits of the FCP framework are very evident. I've just highlighted some on these slides. Of course, we know better consumers, more knowledgeable consumers make better informed choices about their life and are able to manage. Barry, could you go on to the next slide? Sorry. Yes, thank you. Yes, so knowledgeable consumers are able to make better and more informed financial decisions about the products they utilize and even the institutions they choose to do business with. And this came up in the context of the SSL issue in Jamaica, where it was was determined that consumers should also find out a little more about the institutions they're dealing with and hold them accountable. So there is that obligation for financial consumers. Secondly, improve access and fair treatment for vulnerable populations, especially there's focus on access to ATMs, access to branches. We know we are moving onto platforms, mobile and online platforms, but there still must be access for the vulnerable populations. Where online and mobile platforms are used, these still have to consider, or I should say the FSPs still have to consider, how will persons with disabilities access, or persons who are disadvantaged access these platforms. Build consumers' trust in domestic financial markets and promote financial inclusion. We have seen with recent crises in the US that one of the issues was the run on banks and the perception that the financial institutions or the service providers were not acting in the best interest of the consumers, and that there was some misconduct. So trust is very important to the financial system, both at a local level, at a regional level, and I would even say a global level, because of the possibility of contagion. The other three benefits here we have spoken to before, so I won't go into them. And I will just turn to the next steps from the CARICOM Secretariat's perspective. The next step would be submission of the draft CARICOM policy to the COFAB. Of course, this can only happen after there is extensive national consultation with both public and private sector stakeholders. And of course, in this case, private sector stakeholders would be industry as well as civil society and the various consumer bodies, consumer interest groups. Once it's submitted to the Council of Finance and Planning and it's approved, the draft model bill, which is already in-house, will have to be refined. In that context, a technical working group would assist in the refinement of the legislation, the model legislation. This will then go before our Legal Affairs Committee, which is a regional body, for finalization. Upon finalization, the model FCP legislation will be adopted by member states. Member states who currently do not have such legislation in place will have a benchmark by which they can draft their own national legislation, and those who do have it in place and it may not be aligned with this internationally consistent FCP framework will simply have to revise and upgrade those aspects of their financial sector, financial consumer protection legislation that may be deficient. I will note at this time, though, that there is no member state currently who has one in place. I do know that Jamaica has done considerable work in this area. I also acknowledge that Trinidad and Tobago has a financial ombudsman, so too Bahamas, but there isn't any member state with an enacted financial consumer law in place. So the next stage for member states would be, once these approvals are in place and the framework has been finalized, that they will take the necessary steps to implement the framework in order to protect their citizens. I thank you for the opportunity to share what we are doing here at the Secretariat, and I look forward to any questions in the Q&A. Thank you.
Thank you, Cecilia. Now we're going to have our final presentation from Dr. Iris Benor, who will be addressing the issue of consumer credit and debt in the digital environment. Dr. Benor, I should say, is also the lead author of our online consumer protection module. So over to you, Dr. Benor. I know it's been a long wait, but...
Thanks so much. I just also wanted to say very interesting presentation, all of them. And I was also really impressed by this new proposal on financial consumer protection. It seems really relevant and great development. And so my presentation is somehow linked to the previous one because it will zoom in to a specific area, which is consumer credit and debt in the digital environment. And what I will do is provide you with an EU perspective. So in the recent times, there has been an exponential increase of digital and financial products. And therefore, we have seen that the consumer credit sector has been profoundly transformed by the digital transition. And as a result, we can see new lenders, for instance, peer-to-peer lending platforms that have emerged, and also traditional financial providers offer credits online more and more. And what is interesting is that these new innovative lending platforms often use new types of technology to assess the creditworthiness of consumers before they grant a credit. And this raises questions in terms of consumer protection, but also in terms of data protection. And as a result of these developments, we can see that consumers have become more vulnerable. They are financially vulnerable, and there's also an increase of digital vulnerability. In my presentation, I will look at some of these topics, and it is divided in 5 parts. So first, I will provide a brief overview of the context and explain the advantages as well as the disadvantages of digitalization of consumer credit. And then I will briefly touch upon those new crowd lending platforms and what this means for consumers, and the use of those companies of artificial intelligence and big data to assess creditworthiness. And then finally, I will look at the credit regulation that exists in the EU and make some suggestions for reform, because it's actually quite outdated and needs to be adapted to this digital change in the credit sector. So let me now first start with providing a little bit of context and explain the benefits and risks with regard to digitalization of consumer credit. So on one hand, this development has huge benefits for consumers because they have now easier access to information. They can go online and compare products before agreeing to a contract. In addition, consumers also have more choice and funding options, and this is enhanced through this digital offer and those peer-to-peer lending platforms. And finally, there's also faster and easier access to credit. So these are all advantages because obviously access to credits provide consumers with a greater buying power, and they can also invest into the future. However, there are also some downsides and serious risks, which is first of all that now in this fast-paced environment, there is less time for reflection for consumers, and that means that they might take the wrong choice. And also with this development of new products, the different credit options are more complex and difficult to assess. And this is specifically problematic in the financial sector because credit can have a really long-term impact on consumers. For instance, if we look at mortgages, they can, the contracts can have a duration of 20 years or so, and therefore the wrong decision can decrease the wellness of consumers in the long term. And then finally, we also see that the regulators don't manage to keep up with this fast-paced development, and therefore there are some regulatory gaps if I look now specifically at the EU level. And overall, we can see that consumers have become more vulnerable. And there are several reasons for this. On one hand, there is an increase of aggressive online selling practices and advertisements, and this can lead to high-cost short-term credits that is really expensive for consumers and might enhance over-indebtedness. And what we also see from recent reports is that credit is often granted without checking affordability. And that means that consumers access credits that they cannot pay back. And indeed, if we look at the new statistics, we see that many countries are witnessing a marked increase of private debt. According to new reports, there is a 10 to 33% of EU households who have arrears in mortgages, in rent or loans. And therefore, there is a high risk of over-indebtedness, and this has negative consequences. It can lead to evictions and also to social exclusion. If we look at the recent case law in the EU, we can see there has been a growing number of individuals since the crisis, the financial crisis, that encountered difficulties in repaying their debts and therefore risk losing their home. And as a result, there have been many court cases on unfair contractual terms in credit contracts. So there is a real challenge here with regard to debt and unfair contractual terms. And if we look at recent debates, for instance, in the literature, we can see that famous scholars such as Ramsey and Ferretti have highlighted that actually the current credit regulation frameworks that exist, so there are some existing laws that have been implemented in the EU, they are not effective enough, and there is a need for an update. And therefore, the European Commission is currently assessing how to improve their legal framework to make it fit for these new developments and in order to tackle household debt. And there are two key questions that are particularly relevant. First of all, to what extent can the EU law cater for peer-to-peer lending and digitalization, and how can we ensure fairness and tackle over-indebtedness in the digital environment? Now, in order to find an answer, first it's important to understand this increase, for instance, of crowd lending platforms. And this is a digital business model that has become quite important in providing credit for consumers, and it connects those who can lend money to those who need financing. And the investors co-finance projects by lending money to the consumer in return for payment of interests. And the process is quite straightforward. So we can see here that what happens is that the borrower would make an application to the crowd lending platform, and then the crowd lending platform puts the borrower in touch with the private lenders or the institutional lenders. And then if the credit assessment is positive, then the consumer will enter into a contract for this credit agreement. What is really specific about this process is that the entire process is handled by the crowd lending platform. So without really much contact between the consumer and the creditor in exchange for a fee. And what is also worth mentioning is that these new types of lenders, they use an alternative approach to creditworthiness assessment. Now, the creditworthiness assessment is really key and has been included in the EU Consumer Credit Regulation in Article 8, the Consumer Credit Directive, that requires creditors to assess the consumer creditworthiness and use sufficient information from the consumer in order to do this assessment. However, a problem with this is that it's a really vague kind of requirement. And also the court has left a lot of leeway to the creditors. So that means that the creditor has a broad margin of discretion in the determination of the information that they need to use. And as a result, this requirement to assess creditworthiness is not really working effectively. And the key objective, which is to avoid over-indebtedness, therefore is not met sufficiently. And therefore there might be here a need for reform, as I will show later. And what is also interesting to mention is that there's these new providers, those peer-to-peer lending platforms, they apply big data and analytics as a substitute for classic assessment tools and standards of bank credit analysis. And they use a really wide range of data. For instance, that could be the type of shopping consumers make, internet browsing, social media, and other online trails to mathematically then determine the credit risk of consumers. And this also raises question if this way of assessment, first of all, is effective and if it's a fair way of proceeding, and how compliant is this approach with data protection. Now, in order to understand how the EU tried to tackle consumer vulnerability, we have to look specifically at the Consumer Credit Directive. And this is a directive that was already introduced in 2008, so it's actually quite an old legislative act, and it had two key objectives. First, to promote a single credit market through legal harmonization, and also to provide a high level of consumer protection. And what is important to highlight here is that it only has quite a narrow application. And this is something that has been criticized and as problematic, because it only applies to credit agreements ranging from 200 to 75,000 euros. And it excludes quite a lot of other credit agreements, such as mortgages and overdraft facilities. And the problem is that for those consumers who enter into a different type of credit agreements, there might not be sufficient protection, because they would then be excluded from this protection provided by the credit agreement. So there is a need to broaden the scope in order to tackle over-indebtedness. And what is special about this directive is that it has a really strong focus on disclosure. That means that the directive requires that the consumer receive detailed information at an early stage of the contract. So already at the advertising stage and at the pre-contractual stage, consumers are provided with information. And the idea is to render the consumer aware of the total cost, risk, to enable an informed decision. And there are two key points that are worth mentioning. First of all, this directive includes some consumer rights, and here the most important one I would like to highlight is the right to withdrawal from the credit agreement within 14 days. And that's particularly useful also in the digital environment, because as I highlighted before, there is this fast-paced developed environment where consumers take decisions quite quickly without sufficient time to consider if this credit agreement is really the right choice in the longer term. And so this 14 days cooling off period, as it's called, allows the consumer to reconsider and withdraw from the agreement without costs and so on. So it can avoid negative impact if the consumer enters into agreement without sufficient consideration, if this is the right approach. And the second point that is really important and has been described as the most innovative part of the directive in 2008 was the principle of responsible credit or lending. And that contained two main parts. First of all, an obligation of the financial provider to advise the consumer so that the consumer has a better idea what is a suitable credit in the specific circumstance. And that's really useful indeed because of the complexity of the credit options. And then second, an obligation to assess creditworthiness of the consumer to avoid over-indebtedness. These are really important obligations. However, in practice, what we can see is that it didn't work sufficiently well. Why? Because on one hand, there are no specific sanctions mentioned in the directive if the creditor doesn't comply with these obligations. And in addition, there is a lack of criteria that need to be fulfilled in this creditworthiness assessment. And therefore, it's not really precise enough to prevent over-indebtedness and to make this creditworthiness assessment useful. And if we look at the Consumer Credit Directive more generally, there has also, as we see, the approach that has been taken is mainly to focus on consumer information. And in a way, what practice has shown is that this approach is too one-sided because the debtor is seen as a rational decision maker by the Commission or by the EU, while in reality, empirical evidence and behavioral economics have shown that actually individuals are not always able to take rational decisions, and therefore they're often manipulated by advertising and take decisions that are not suitable. And vulnerable groups such as the elderly, the young, or the uneducated are particularly affected by this. And therefore, there is a strong opinion for instance, in the literature that there should be a stronger focus actually on quality of information rather than quantity in order to avoid information overloads. And now I'm coming to my last point, which is the question, how does this legal framework deal with those new types of lenders, the crowdfunding lenders and the P2P lending? And what is interesting to mention is that the credit regulation sees those lending platforms as credit intermediaries. That means that they have certain obligations, they have to inform the consumers, but it does not provide a clear duty to assess the creditworthiness for those platforms. And that's problematic because, as I showed before, the platforms usually are the only link between consumers and creditors, and therefore there would be a need to include those new providers of credit, those platforms, in this credit regulation framework to ensure that they do apply an effective creditworthiness assessment, and that might then help to avoid over-indebtedness in the future. So I'm coming now to my conclusion, and this also contains somehow some suggestions how this regulatory framework could be improved and updated. And there are three key points to this. First, there is a need for a better adaptation to this digital innovation. Second, there is a need to create a framework that really ensures that responsible lending is effective. And then finally, and crucially, there is a need for debt solution procedures. And first of all, what is important here is first to provide a broader coverage of the Consumer Credit Act, for instance, to include also regulation for those peer-to-peer lending platforms. Second, it's crucial that there is some clarification how this creditworthiness assessment should be performed to make it effective. And then there's a great need also to improve digital as well as financial literacy for consumers through education programs and advertisement. And another element that hasn't been included and has been recommended by the international guidelines that were mentioned previously by Ms. Melville, for instance, by the World Bank and the OECD, as well as the UN, it's essential to include principles of fair treatment and good conduct by financial providers. And it's something that is unfortunately missing in the consumer credit regulation, in the consumer credit directive that I mentioned before. And then finally, for those consumers that are highly indebted and in a vicious circle, and therefore for those ones where it's really difficult to get out of this, it is important to provide debt advice services and also to provide them with personal insolvency procedures that can help them to get out of this vicious circle, and so they can integrate again into society and into the economy. And that brings me to the end of this presentation. Thanks very much for your attention. I'm happy to reply to any questions.
Thank you, Iris. Much appreciated for staying on the call. We know it's been a long, in your case, a long night. So, colleagues, those of us who are still online, are there any questions that you would like answered on any of the presentation topics? We look forward to either seeing those in the chat, or persons can provide their questions directly to the presenters. So the floor is open to participants.
You had a question from Anne-Marie a little earlier before Iris commenced, after Sasha's presentation. If Anne-Marie is still online, I think she can probably ask it.
Yes, I'll put it very bluntly. We have a consumer protection regime. There should be an impact on the court system because a lot of those cases should now end up under the free system. So my question was, has Jamaica seen any notable differences in the cases coming in its district courts with the implementation of the CPA regime? Thank you.
Sasha, over to you.
Hi, can you repeat the question? I'm having some connectivity issues. Hello?
Hello, yes, it's Anne from St. Lucia. My question was looking at the CPA regime that you've introduced, which seems to be very successful. What impact has that had on the district courts and the number of consumers having shifted or transferred? So it's a volume thing. Have you noticed a substantial change in where cases are going? Thank you.
The truth is that we place such a high reliance on matters getting settled that we really don't place, most of the matters are not placed before the courts or before the tribunal. And I've been here since 2014. All the matters that I've placed before the courts, they get settled before trial. So either they get settled at the case management conference, or in our legal system in Jamaica, based on the civil procedure rules, you have to do mediation before you proceed to trial. So it either gets settled at that mediation stage, or it gets settled at a case management conference, but they don't actually proceed to trial. So for most of our matters, the mediation or any kind of alternative dispute resolution, that is where our primary focus is, which is why we have an 80% resolution rate for our cases, because we really, really try to push ADR. Litigation is even though I'm the attorney and everything, but the truth of the matter is that I discourage consumers and vendors from going down that avenue, because at the end of the day, the consumer wants an item that is functioning properly, and the vendor wants to get their business up and going, and they want to make a profit. So we have to find a way to work together in the marketplace without, having the back and forth. So we focus mostly on ADR techniques, and when it does go to litigation, it never goes to trial. It always settles before. That is for the Supreme Court and for the parish court. For the tribunal, though, when the matters are placed before the tribunal, we find that the turnaround time is much faster than if we had put it before court, obviously, because it takes a longer period of time. And even then, we still try to mediate whilst that whole process is going on. Sometimes you find that vendors will make an offer and we won't carry on with the case. So it just really depends on the circumstances. But mediation and ADR, that is what we try to do here, mostly.
Thank you.
All right, you're welcome.
Go ahead, Caricom.
Okay, Barry, it's me, Cecilia, actually. So I will pose my question to the last speaker, and then you can raise your one from the floor with me after she's finished answering. I took note that she mentioned that household debt distress is one of the major issues being treated with under the directive. And I was interested to know how receptive are financial institutions with regard to implementing procedures to alleviate household debt distress. And the context for me is that in the CARICOM region, I don't think there's much latitude. Well, certainly there's nothing in law that requires financial institutions to engage in loan restructuring or to address the concerns of vulnerable consumers. So I'm curious to know how is it working in the EU, and what leverage is used to ensure that the financial institutions give this consideration to vulnerable groups. Thank you.
Dr. Benor, if you could address that question.
Yes. So at the EU level, there are no specific bankruptcy procedures that have been implemented, unfortunately. So there might be at national level some who allow an easier kind of getting out of the debt or indebtedness, but at the EU level there is no such thing, and that's missing. It's something that needs to be addressed, actually, and it hasn't been, I think, adopted because the situation the different countries are in, right? The social and political situation are quite different, and so I think that was one of the reasons why it hasn't been addressed yet. But it's something that is highly recommended also at international level, that countries should have a system that cures debt once it's there, that helps especially those who will never get out of the debt trap. There are those that consumers who don't have sufficient income to ever relieve themselves from high indebtedness. And then, well, what regards the businesses, so the financial providers, it really depends on the providers. Some might give extra time or give warnings to consumers in order to prevent that they really get into the highest type of over-indebtedness. But I think it's more a question of, of their willingness to do that. It's not something that they would have to do. It depends on the different types of providers somehow, if they want to engage and help out in this. In a way, they also have an interest, obviously, because they want to be paid back. But the problem is quite a lot of them might actually can impose extra penalties and high interest rates and so on. And so some of them, they might, for them, it's a good business case actually to keep consumers over indebted. So that's a little bit a problematic issue with debt and over indebtedness. And then I saw also there was another question by Sunil Gopal online. I just saw this in the chat. Shall I reply to this directly or?
Yes,
You
go
can
ahead. Go
reply,
ahead.
and we can also have Cecilia after that.
Right. Okay. So are there any recommendation or suggestion for expanding the coverage of the consumer credit regulation? Yes, there are. So one option would be to increase the credit agreements that would fall under this directive. And this could be, for instance, by lowering the current threshold, because now only credits that are between 200 and 75,000 euros are covered. And what could be done is to have no lower threshold so that all credits are covered by the directive. And that's quite important. And it has been also discussed in the literature because the idea initially by the regulator was where small credits have less of an impact, there's less risk of over-indebtedness. But in practice, what can be seen is that consumers can build up different types of credit, and all this together, even if they're small, they can eventually lead to over-indebtedness. And especially the small credits are those high rate cost credits, and that's a problem. And therefore, it's actually useful that those types of credits are also covered so that consumers benefit from this higher protection that exists in this case. And then there's also this limit of 75,000, which in my opinion, it's not really understandable. Why should a higher credit be, if there's a higher credit provided to consumer, why should then the protection be less? I think there's a great, it would be great to just higher also the threshold that exists now. And so that would be a broader scope of the directive. And then also what needs to be done is to cover all those new types of lending platforms and so on, so that they have the same kind of obligations that creditors have, because in a way they take over a little bit the creditor's role in assessing credit worthiness and all that. Yeah. And then there was another question, sorry, it's a bit long here, but how can the principle of fair treatment and good conduct by financial providers be included? Well, there is already a good example, and this is the Mortgage Credit Directive. This exists in the EU, and this has taken account of the international recommendation, and it contains specific kind of requirements that the providers have to apply fair treatment for consumers, and especially what is important also, the creditor has to avoid conflict of interest when they provide advice to consumers, which is not always easy, because one reason, or what has also fueled over indebtedness, is that obviously the financial service providers have an interest to sell products, and therefore this can lead to aggressive selling practices that are not in the interest of the consumer. So the regulator was trying to include this kind of obligation to avoid extra payments for their staff if they get more consumers on board and so on. So to avoid incentives to kind of not act in the best interest of consumers. So that are just some examples of best practices that could be included.
Thank you, Executive Director. So to those who have remained throughout the entire session, thank you. We appreciate your interest and your questions that were received. We want to thank the presenters who are still here, all those agency stakeholders who have an interest in the topics that we discussed today. And if there are any further questions that y'all want answered, please send your emails to us and we'll try our best to get the subject matter experts to provide as comprehensive an answer as possible to your questions. So I want to say thank you all again. Take care. Enjoy the rest of your day or night, as the case may be. And then we conclude today's session.